welcome to the third panel discussion of this conference. What we will be discussing is on corporate law and business ethics. Our endeavor in this session is going to be to discuss the existing regulatory regime that we have, where it succeeds, where it fails, and why, despite so many compliance requirements, corporate fraud still persists. We have the SEBI regulations, we have the provisions in the Companies Act, but we still see corporate fraud persisting. We have an excellent panel with us today. I'd like to first introduce Mr. N.L. Rajah, Senior Advocate practicing in the Madras High Court. We have Advocate Deepika Murali, who is also practicing in the Madras High Court. And we have Dr. R. Kesavamoorthy, Professor at VIT School of Law. A very warm welcome to all of you. If we could begin the discussion primarily first speaking about what the challenges exist when it comes to the regulatory regime that we have. Mr. Rajah, if we could begin with you, please.
Yes. Good evening to all of you. Today, we would all know that if you take the 100 top economic entities in the world, it is not going to be governments. The majority will be corporates. Many corporates have budgets which are bigger. Many multinational corporates have budgets which are bigger than the Tamil Nadu government. So today when you talk about a corporate as an entity, you will have to talk about rules of governance rather than rules of business management, because that's how big businesses have become. So in this world of constantly evolving business standards and business practices, the challenge of law to keep up with the pace of change of business strategies and the various methods of business is a very real one. And the main challenge has been how is law to keep up with these changes. And if you would, I don't know how many of you have read the book Nexus by Yuval Noah Harari. It's a very interesting book which sets out how the future is going to be determined by AI. So many of the things that we take for granted today, we do not know that it is actually being generated by AI, it is directed by AI, it is regulated by AI. Given these complexities, he says there are going to be machines which are going to talk to each other, computers which are going to talk to each other. It will completely eliminate the necessary for a human interface, and it will come up with financial documents which none of us will understand. And the impact of these financial documents on global business, on global strategies, on how businesses will proceed is going to be mind-boggling. So for the first time in human history, we would completely lose control of what we are doing. You just build the necessary algorithms. The algorithms will see to it that they come up with systems. These systems will between themselves discuss and come up with financial tools. It will come up with means by which businesses can be regulated. So this is a huge challenge which the infusion of technology into business is posing. There's another very interesting book called Future Shock by an author called Alvin Toffler. If you take all of human race and the life of human race on earth and condense it into a 24-hour period, it is in the 11th hour, 23 hours, 57th minute that man invented electricity, right? So from all this period, the last 3 seconds, so to say, have made such huge change in human progress. And now if we can imagine what type of progress is going to result from infusion of technology into business. Therefore, it is in these circumstances that it is necessary for human minds to come up with standards relating to ethics. And with regard to ethics, there are different views. For example, Peter Drucker says that there need not be any ethics for businesses, because if every human being is going to be ethical, there would be no necessity for ethics in business. Now, very many authors do not agree with this standpoint, but that discussion is going to go on. But what can law do to regulate it is going to be the challenge which we are going to discuss in the next few minutes.
Thank you, sir. Ms. Murali, what is your opinion on this?
So, while researching for today's discussion, so we had the occasion to see what are the regulatory mechanisms available in India. And I know there was a question put specifically on looking westward. And if you look at today's company law and the newer IBC and everything, there is a lot we take from what is first brought out abroad and then we inculcate it here. So, including in company law, whatever are the evolutions we see which happens first in the UK or the US, there is a lot that we imbibe into our policies here. So, on that note, while there are some things which we seem to have blindly taken forth, for instance, like bringing in independent directors to be on the board, various other regulatory mechanisms governing like directors and listed companies. SEBI, like you all know, if you've had a course on company law, the LODR requirement specifically states what should be the regulatory framework which has to be met by a company. You also have the new Companies Act 2013, in which there is 177 and various other sections which speak about what are the audit mechanisms and what vigilance should be there. But there is a very, compare that to say your, the UK laws on whistleblower policy or the US Sarbanes-Oxley from 2002. We did have a Whistleblowers Act, which was a bill which was passed, which later became an act, but I think it's been dormant for more than a decade now. So we seem to be taking what is most convenient, and when it is not, for instance, the whistleblowers policy, we seem to be very inconveniently brushing that aside. So we all know, be it with, say, journalists, including the very unfortunate incident from January in Bastar of a journalist being murdered for exposing corruption, to other whistleblowers who have not met a not so pleasant fate. We know that this corruption and things is part of governance which is happening, and transparency would bring in a lot more accountability and corporate governance procedures as well. But what we are seeing is that not being followed, the act not being coming in, and because of that we are facing a lot of other issues in the general corporate space that we know as is today. The second issue that I want to speak about, moving on from whistleblowers and policy and everything, is specifically if we look at Corporate Law, Companies Act and all the governance that is there. Yes, like again I spoke about audit mechanisms and the need for a better system in that place. We do need some sort of amendment as well to the Parent Act, which is the Companies Act, to bring in some sort of insurance and protection for the directors as well. Here I will dwell a little into judgments that have recently been in the news. You may have or may not have seen, there is a judgment last month of the Supreme Court in Sanjay Dutt, not the actor, versus State of Haryana, which spoke on how much a director can be held vicariously liable when they've not been directly involved in an act which the company is accused of doing. You all may also have done some amount of Negotiable Instruments Act in your criminal courses and everything, where directors are generally being made liable. Now, the jurisprudence which flows from these Negotiable Instrument Act cases and this recent one that I spoke about is that you can't make a director blindly a party, blindly an accused to such litigation. There has to be some cause and effect. Yes, a director may be an agent of the company, but that doesn't mean they can be added to each and every litigation, and you can't presume that they are guilty, and you can't presume that they were involved in the transaction. That is one part of it. The second part of it is something which again is there westward, which is the D&O insurance, which is the directors and officials insurance, which is something which we don't yet have in India. There is some chatter about trying to inculcate that into legislation and everything, but probably that can only come into by way of an amendment to the Companies Act. So my 2 bits on this is, just to summarize, Whistleblowers Act, we still are nowhere near that. And secondly, any vicarious liability being foisted on a director, there is some jurisprudence on that, but something more codified will be needed to take this forward.
Thank you, Ms. Murali. We'll actually discuss whistleblower protection and the need for legislation in India a little bit more in detail. But before we go to that, Professor, I'd like to come to you. Do you agree with Ms. Murali that there are statutory reforms required? And do we take inspiration from other jurisdictions in this aspect?
First of all, I am very honored to share the dais with the two eminent speakers here. My point here is I would see Professor Palmer in his book 1909, 100 years back. He has stated that what actually you are going to do after 100 years down the line is going to be decided by the corporates. Your lifestyle, what you wear, what you do, your life's value itself is decided by the corporates. Down the line 100 years, what I would see now is we are in that future, meaning the corporates are actually deciding what we're supposed to do and supposed not to do. That is where we are in. So as a senior advocate was rightly pointed out, there are so many legislations that we have adapted from the Western countries actually. If you read the work of Davis, one of the acclaimed authors in corporate laws, he actually quoted this. The mistake that every research carries is that all the westernized data were used to do a research. Say suppose if Indian laws needs to have certain changes, that should be brought from the data collected in India. Where if you see the post-colonial era where we are in right now, all the colonial laws actually, westernized laws were actually made into Indian laws, especially if it comes to commercial and corporate laws. Because of that, what we have lost here is the entire history of India has been lost in commercial and trade and mercantile laws that we had earlier. We lost the entire chain of it. And there is not much research is taking place in that particular area because the funding that has been given by the government is very, very less in this area. So with that, if more of funding, the more of research that takes place in those aspects will actually improve the current legal regime that we can have an opt legislation for India. As Ms. Murali was rightly pointing out, those ethical issues that are brought from Western countries, how that can be adapted to India, that needs to be looked into, especially if it comes to SEBI regulations. And SEBI regulations, very many regulations that has been brought in by the SEBI are actually coming from the Western countries to satisfy the needs of the cross-border, commercial trades and, commerce. So I think that is where we have to throw a light on that. With this note, maybe if the chance comes again with different topics, I can speak.
Yes.
Yeah. Thank you.
Yes, of course. Thank you, Professor. Mr. Rajah, coming to you, Ms. Murali did speak about vicarious liability of directors. According to you, are there reforms required in that space? How do directors shield themselves from personal liability while at the same time ensuring that there is corporate compliance?
Yeah, on that topic, I made a list of, because we sort of discussed what we should be talking about so that this does not go unstructured. So I made a list of, before we talk about liabilities, we have to talk about corporate responsibilities. What is a director's responsibility? 6 main responsibilities have been identified in addition to others. These are financial reporting and disclosure, board processes, related party transactions, compliance with labor and employment laws, environmental regulations and compliance with them, and taxation compliance. Now there are 2 ways of managing this. One is put in place better governance, corporate governance, which will ensure that there might not be exposure to any liability. Now how do you do that? So the internationally recognized methods is A, robust internal controls, B, regular training of staff and people associated with your company to ensure business behavior that will ensure that there is no cause for any allegation of misappropriation or anything that is illegal being thrown against the company. Engaging professional advisors and taking their advice as to how do you structure the corporate governance in a company, and giving respect to whistleblower mechanisms. These are what you could do at a corporate management level. In addition to this, you must also remember that the law itself provides for certain safeguards. When you talk about directors of a company, you're talking about non-executive directors and full-time directors. As far as full-time directors are concerned, there is a huge liability on them and there is no safe harbor clause. But as far as non-executive directors are concerned, you need to show that they were aware that something had gone wrong, that there is scope for a charge of negligence, they remained negligent and therefore were liable. So the safe harbor provisions of the Companies Act ensure that as far as the non-executive directors are concerned, there is a provision that they can plead. Well, in respect of full-time directors also, you could say that this happened and this was beyond my control. Now, what are these? These are statutory safeguards. Beyond statutory safeguards, there is also something that the company can do in terms of internal management. And one is, it can create indemnity clauses in the memorandum and articles of association, which empower a company to indemnify its directors. But beyond this memorandum and articles of association indemnification, it would also make sense for the company to execute proper agreements with its directors, which stipulate that in case that they are put to any financial loss, that the company will indemnify them for that. Please understand, this was specifically prohibited under the 1956 Act. On the other hand, in the 2013 Act, there is no specific prohibition, and it is possible for companies, and in fact, any person who gets onto a board as an independent director must insist that there is an indemnification and there is an indemnity bond that is executed by the company. While that bond is being executed, the director must also ensure that it extends beyond the period of his retirement also and covers him for any charge that may be made against him after his retirement. And as Deepika was talking about, there are now P&O, the principal officers, the directors and officers insurance that are available, which the company can take. So these are the three stages at which the directors can safeguard themselves.
Thank you, sir. That's actually an excellent point, making sure that directors agree and the company actually agrees to indemnification clauses, some very good practical safeguards. Ms. Murali, coming to you, what experts have pointed out is that we are seeing a lot of criminalization taking place. Is it important to differentiate between deliberate misconduct and mere lapses in oversight when it comes to liability of directors, and how do we ensure that?
To answer that, a practical example would be, say, the new not so new insolvency and bankruptcy code, which, as some of you might have had in your courses, it is something where we have seen a lot of amendments being made to, and a lot of rules and regulations are attached to the Parent Act. Now, specifically from 63 to 66, there is something called fraudulent transactions and transactions of an avoidance nature. These are some things on which there is a lot of litigation happening at our company tribunals. Now, even in these sections, 63, 65 and 66, there is a particular look-back period given. There is a look-back period, I think, of about 2 years for certain avoidance transactions and a little bit more when it comes to fraudulent transactions. But as someone who litigates in the court and represents independent directors and companies, a lot of these are filed by the resolution professionals who are appointed to take charge of the company without any real application of mind, which leads to a huge boom in the number of judgments which come out on this subject. For instance, there will be actually no causal relationship at all to the instance of fraud that had happened to a particular director. She might have just been a director at that point in time, but even then, she would be arrayed as a respondent in these proceedings. Time and again, the law has been pretty clear that you will have to establish a relationship to show that this director was liable, they were in the know of this transaction, be it of a fraudulent nature or of an avoidance nature, and they actively participated in this, and hence they ought to be made liable. But generally, when RPs prefer these applications, these rules are given a go by, And what we see is very standard form applications being filed, and directors have to come to the court and justify how they were not even part of the board meeting in which this decision was taken, or B, they were not even in the know about these avoidance of fraudulent transactions. Just to add for another minute here, there are two principles which one could sort of find mention in 463 of Companies Act, which is something called a business judgment rule, which is something where a director may do something in good faith, like any action taken in good faith, which we may know from other subjects of law as well, and something called a care mark standard, which comes from a Delaware court judgment as well. Those are two things you guys can look up on understanding the genesis of why certain things have been put in 463 of Companies Act. Now, these will include certain measures for the directors to protect themselves, but again, specifically on 463, while there might not be too much active litigation going on 66 and other provisions of IBC, there is some discussion going all the way up to Supreme Court. There is jurisprudence on that.
Thank you, Ms. Murali. If we could now talk a little about the whistleblower protection regime that we have in India, or rather the non-existence of it. Professor, I'd like to come to you on that. Do we require a dedicated law protecting whistleblowers? And more importantly, is it important that this law covers both the private sector as well as the public sector?
Okay. So this so far in India is concerned, where the whistleblower laws are actually well implemented in public enterprises and industries. It has not been reached to the level of public corporates and private companies down the line. Meaning, there is no such law which is existing right now to tackle with the whistleblowers. Again, as I said in my opening remarks, we are looking at the westernized codes for the whistleblowers also, where we are talking about more of ethical and cultural implementations in the whistleblowing, where we should look into our ethos systems and cultural barriers that we have in not only bringing in this legislation, also we have to implement it effectively. For that, we must look into the Indian cultural and ethos barriers that we have. Especially if you ask me what are the ethical barriers that we have and the cultural barriers that we can encounter when we bring in these kind of whistleblowing legislation. See, now in our society you see that there is a hierarchical pattern which is existing, where I should obey what my bosses are saying. I cannot deny what they were saying, I cannot go against them, I cannot represent myself to them. That is the greatest barrier that we have. And other things, if you look into it, the power dynamics, which is very different from that of the westernized countries in India. The power dynamic works in a different way. Now, there is a theory, if you look into, where it is written by Henry Maine. He said the power distance theory. The power distance theory, actually, the more the information that you have, the more the powerful that you become. That applies to the corporates also. So that is, the people who are having more power will be encountered with these kind of a whistleblowing. How do I, as an employee, or as a whistleblower, how do I come out and say my boss is doing something which is wrong? And this actually creates a social stigma and career stigma here if it comes to corporates. The career stigma actually cripples his growth in his profession, and he will be stamped as person who won't obey to anything. And this stigma, again, it comes from the ethics that we have. And if you look into the whistleblowing, the lack of awareness among the people, which is those who actually has the information in their hand. And the awareness needs to be created. And the robust legal protection needs to be given to those people who comes up and say, and this is something which is wrong is happening in my company, and that needs to be taken into consideration. So these things needs to be first addressed, and then we should think about a law which can be brought into India and implementation of it. So that is what.
Thank you, Professor. Some excellent insight. There are actually so many cultural barriers that I think we as Indian corporate employees face, we are so differential, there's so much of loyalty to our employer that we'll think twice before reporting any misconduct whatsoever. But coming to the existing regulations that we have, Ms. Murali, we have a host of SEBI regulations. In fact, the SEBI Prohibition of Insider Trading Regulations 2015, we've had a set of regulations in 2019 as well. They also offer monetary incentives. But why is it that we don't see whistleblower reports?
So, I'll draw a corollary here. Let us look at our workplace harassment laws, which protect women. You have a specific legislation, which is the Workplace Harassment Protection, Prohibition and Redressal Act of 2013 with rules. Now, initially, you all know the genesis behind it, which is the Vishaka judgment, which Shabnam spoke about. Now, when the act came in, there was a lot of confusion on compliances, who should comply, and of course, the law is pretty clear on who should, anyone above having more than 10 employees, any 10 people working, that is. So that sets down, if you have more than 10 employees, then you must have a ICC, who should be part of the ICC, all that is mentioned in that. Now, though this law is, say, about 12, 13 years in, we are seeing implementation being done in letter and in spirit. And especially with, the Me Too movement, which took over again in the US and pretty much all over the world, we did have this act in place which covers workplace harassment. And all companies are expected to comply with it. So that is what I feel is missing, because we don't have a specific act for the whistleblowers, which is called the Whistleblowers Act. Though, again, when we had looked into this, all we could see is there was an act, there was a bill, it became an act, and suddenly there is a PIB notification saying we are not going to notify it anymore. And that notification is over a decade old. So obviously now a new act will be required. Discussions will have to be made on what could be the new act, because let's face it, times have changed in the past decade. So clearly the old bill may not work anymore. But what I'm trying to say is that, like you have a specific legislation for regulating what kind of complaints are, how to handle a complaint under workplace harassment, a specific policy, a specific act, if it is there, to sort of get into how a complaint on a whistleblower's this thing is to be handled, that would sort of go a long way. Because all you have today is, I think, subsection 9 and 10 of 177 on a vigil mechanism, and that a company is supposed to have this vigil mechanism and report it in their annual report. That is all that you have. So what is then the penalty for non-compliance? And we all know if there is no non-compliance mechanism, companies might not follow, even if they are a listed company. So it all boils down to the fact that, like Professor had said, a specific legislation in tune with the ethos of how we are as a country, especially like he said on like how we are ethically, how there is still an element of subservience and complying with what your superior says. So taking all that into account, we will have to have a specific act in place.
Thank you, Ms. Murali. If we could now talk a little about the compliance requirements that companies are now supposed to follow under the new draft rules of the Union government introduced back in January for the digital personal data protection rules. Coming to you, Mr. Rajah, what do you think are the compliance challenges that companies can face when it comes to the rules?
This is a huge subject, and it's a very infant stage. And as a practicing lawyer to a whole host of young minds who are seated here, let me tell you one thing. When you start tracking emerging laws, right? You go into labor law, criminal law, civil law, it is flooded with lawyers who are practicing in that branch, and for you to make a dent in that practice and to rise in your profession is going to be a challenge. So if you are going to be prudent, what you must do is constantly track emerging laws like this data protection, because there will be nobody there, because nobody knows this law. Start writing about it, start speaking about it, start interacting with professionals who know something about it, and get to be heard. It is easy for you to be heard in the present day and time when social media can push your thought process out into the open. It was very difficult in our times, but in your times it is possible. So one of the things that is an emerging law is a law relating to data protection. I would request, how many of you know that there is a law relating to data protection here at all? Is it part of your syllabus? I'm sure that it's not part of your syllabus. Have you studied about data protection law? I'm sure many of you have. Very good. That's excellent. So that's what youngsters must do. This is an emerging law, and it is, as our moderator has asked me, it's going to have a huge impact on corporates. It's going to have a huge impact on how corporates store their data. What is a significant data fiduciary? See, there are two rights which are sought to be balanced in this legislation. One is the right to privacy of the citizen, and the other is a right to benefit from certain data which you can get. For example, I run a hospital, and let's say the hospital has 1,000 cases. The hospital administers a particular drug to a particular patient, or patients who are suffering from particular ailments, right? Now this data, which that patient, who's called the principal data, he's a person from whom the data is going to emerge. Now his consent is necessary to deal with this data. So this data which you get out of that person can be used for public good if you can sort of run it through a processing unit, find out how effective it has been on some patients, why has it not been effective on other patients, what is the physiological condition that blocks this drug from being effective with other patients. This is a huge source of information which society can use to improve its processes and systems. I'm only giving you a very small example. On the other hand is the right to privacy, which has now been recognized by the Supreme Court. Of course, in the MP Sharma case and in the Karak Singh case, the Supreme Court held that there is no right to privacy. And the wonderful thing about our constitution is every right which is prohibited is also allowed. Every right which is allowed is also prohibited, right? You have a right to start a business, but you can't start casinos all over the country, because starting casinos all over the country is prohibited. So, and you have a right to life, but within the provision of right to life itself is a provision with regard to detention, right? Preventive detention. So it's very strange in the constitution that every right that is permitted is also prohibited, and every right that is prohibited is also in some way permitted. So privacy as a right was the learned judges who heard the case earlier held that the constitution does not hold out any promise for protection of privacy. But in Puttaswamy case, the constitution bench of the Supreme Court completely reversed the judgment and said, yes, we recognize right to privacy, but that right to privacy is going to be regulated, it is going to be modified, and it will be accepted on certain terms. So this is the challenge between data protection and the right of society to benefit from that data. How we regulate it is a huge challenge. As I've always said, that in India, act as a noun is very easy to achieve. You want an act to be passed, act will be passed. Parliament will pass an act, assembly will pass an act. But act as a verb is very difficult to achieve. Act, to work an act, to actually see that it is enforced, that it is implemented, is going to be difficult. This is an emerging law which is going to throw up a lot of challenges, primarily in this balance between protecting privacy and ensuring that the data that is available, which could be processed for private good, how is this balance to be done is what this law attempts to enact. We do not have many cases emerging under the provisions of the Act to see whether this Act is effective, but there must be. I will just stop with saying this. Most advanced countries will have a legislation oversight committee which will constantly keep vigil over judgments that are passed by courts interpreting particular provisions. When there are conflicting judgments and there is a difficulty in implementing the law, like in India, do not wait for the Supreme Court to decide that issue. And once the Supreme Court has decided the issue, it will decide to redecide the issue, and then it will once again redecide the issue. This process most countries don't go through, because the Legislative Oversight Committee immediately picks up the issue, has an in-depth discussion on that, and brings in amendment. That's how effective a legal regime should be. But unfortunately in India, we do not follow that method. Therefore, it is, as the famous jurist Oliver Wendell Holmes said, The life of law is not logic, it is experience. And it is human experience that feeds legislation, right? So please do not look for anything logical in law. At your level, one simple example is 35% I get, I pass. 34 marks I get, I fail. What is the great difference between 34 marks and 35 marks? That is logic. But logic does not feed law. It does not feed regulations. It does not feed rules. So what feeds regulations are human experience. Human experience must show that there has to be some sort of a classification, and that classification will have to be implemented. This is basically what the Data Protection Act attempts to do. The challenges are interesting. I would request all of you to get engaged in the process of finding out where this law must go. Thank you.
Thank you, sir. Ms. Murali, just a quick response because we are running out of time. Do you see this increasing operation costs for companies, especially because there's also a higher penalty for bigger tech companies, significant data fiduciaries? How do you see that playing out?
Yeah. So I think from when these bills have been in discussion, there has been a lot of pushback from tech companies. And so while we do have a Parent Act from 2023, there is one bill as well of 2025, but from whatever we could see as well, there are a lot of issues that, A, companies may face, and two, there are some lacunae which the government has probably overlooked. One such this thing is what we could see was data localization. How much of it is Indian data is stored here, and what can be in fact taken out of the country, and whether data hubs are being created here. So that is something we see woefully absent in the Act, and we know as lawyers it can't be overcome just by way of a bill, by way of like a rule or a regulation. It will require an amendment. So with respect to data protection laws, yes, probably like various amendments we see to arbitration and IBC Acts, this may also be an act which may undergo a lot of amendments, and we probably are a while away from having something which is something which regulates the bodies that are the stakeholders which are here in this. But at the same time, I think we are a while away from where we are today. Only on a lighter note, and because I know time's up, I remember this line from Family Man which says, democracy and privacy both are an issue in India. So I would conclude with that.
Very well said. Professor, some concluding thoughts on this before we move on to the Q&A session.
Yes. This as I agree with Ms. Murali and Mr. Rajah, who is senior advocate. I would see this, the word you see, the significant data, fiduciary. If you see the significant, the word, it is an adjective. Data and fiduciary is a non-measurable word, meaning we are going to go to the court and middle with these particular terms actually. And as a reader of corporate law for a decade, I see that how the drafting has been changed over the period of time. Our legislation's drafting have been changed over the period of time. And now more of an adjective has been used, more of a non-measurable terms have been used, where the judiciary has to throw a light on it. There is no other choice available where we both have to fight in the court and get a clarity to it. Thank you.
So another area of law, there will be increased litigation. Now we'll move on to the Q&A session. Any questions from the audience? Yes, please. If you could please also introduce yourself.
So myself, Sujashri, I am studying 4th year Law BA. So labor exploitation has been persistent till today. It's due to a stigma that labor investment is not that much outweighs the financial investment. Why not India follows a dual board system rather than a single board system of corporate governance, so that they can give an equal representation to the labor unions and the company representatives, other than giving the most of the power to a board of directors?
Well, that may be, it all depends upon how courts are going to treat such a drastic change in the way the board is being managed, in the way the company is being managed. But more and more labor laws, I think, give some voice to the persons who work for the companies. And the thing is that it will definitely be challenged in courts. And constitutional promise that I have a right to run my business, how far is this an incursion and an invasion into that right will have to be decided, because basic form of any business is that somebody invests capital and the workmen come in as labor and they participate. There are other forms in which a cooperative movement is possible. Through a cooperative society, you run an organization where the labor is also part of the management. But unfortunately, as an experiment, it's a measure that failed. And that's why we have this corporate way of managing this. Cooperative society, cooperative movement, somebody has to write a book on why the cooperative society movement failed, because that talks about the way that you are suggesting, that the labor itself will have a say in the way that the company is being managed and the government will bring in the funds. But that unfortunately failed in the country. And since we have a precedent to show that that has failed, I don't think that's going to be replicated again.
Ms. Murali, would you like to respond to?
Not really. I think I'd pretty much go with what Sir says. But, yeah.
Yeah, this corporate governance, we had a length of discussion in the classes also with her actually. Because, this dual board system and single board system actually comes from the cultural identity of the country actually. So if you look into the Japan and Germany, it is these corporate governance models are actually cultural identity than a regulation. Because these cultural identities are recognized as a regulation, then we have absorbed it into the Companies Act. Now if you see the German, it is more of industry driven. And the industrial revolutions, World War, all those have been demanded to have a dual board system. And this dual board system is, the supervisory board will be there above the board of directors. That is the dual board system. So if that is the case, India has to go a long way to have a dual board structure here. So we have adopted a convenient single board system from the westernized countries again. So that is what I could say.
Thank you, sir. Thank you.
Any more questions, please?
Yes, ma'am. My name is Abhishek. Good afternoon to afternoon to all of you on the dais. So my basic question is, should companies under the Companies Act be able to be sued by other people who, because under the Whistleblowers Act and as under Article 12 of the Constitution, which is being considered as a state, should they be able to get sued, considering that they are limiting their employees' right to freedom of speech and expression if they're not able to, be a whistleblower under the Whistleblowers Act?
I could just briefly tell you that, but one is, I think many of the listed companies do have a policy in place. So if you look at, say, your large-scale insurance companies, which some state-owned companies as well, or even say a private company, a listed company, they do have a policy in place, a vigilance mechanism like I was discussing. So your question is, what happens in the absence of a policy, right?
Yes, ma'am.
So again, if there is a policy and if it is reported, then it will have to follow the due process. Say they report to a listing authority and the complaint is taken up, that will follow its due process. So your question is, what if there is no policy and they do come to know of any misdeed by the... So then you would resort back to your criminal avenues that are available, right? Like say you do have knowledge of a criminal act. As an employee, you do know that a director is colluding with with another regulatory body's employee to defraud the investors. Then while criminal avenues and of course going to the press and those are available, your question is whether any writ would lie? Is that...
No, ma'am. Because in previous judgments in the Supreme Court or other high courts as well, in Article 12 has been described as an avenue for different, especially in the case of education institutions and very few companies, it has been described as an avenue to go through as they perform a public duty towards the public in order
Correct.
but they perform a duty to the public. So should there be an avenue through Article 12 for them, for these whistleblowers to express their opinions and come out to the public?
I'm not sure whether the answer to that question is yes. I would say probably still a need for a separate legislation than going under Article 12, because while there have been judgments for the past several years on interpreting Article 12, I'm not so sure whether the remedy may only lie there. And I still agree with the other panelists that it will have to be a separate legislation.
many of you have heard of Satyendranath Dubey? Who is he? Exactly. So I'm very glad that there is somebody who knows about him, because you should all read about that, because he was the person who actually wanted to expose the corruption in the highways, the company which is doing a highways project, and he sent a complaint to the government, and the government quite intelligently bundled up his complaint and sent it to the person against whom the complaint was made. And in a short while, the poor man got killed. And it was the furor that death created that led to the awareness about the need to have a law to regulate whistleblowers. Unfortunately, even though that law has been passed by Parliament, it has not been notified. Whistleblowers, activists are very relieved that it has not been passed by Parliament, because they say that the act itself is faulty, because there is no, it only talks about government employees, and it still does not provide for the identity of the whistleblower to be kept anonymous, which is the main thing, which is the reason why that act was passed. But surprisingly, there is no provision in the act which ensures that the identity of the person who is a whistleblower will be kept anonymous. So these are the misgivings of activists about the Whistleblowers Act. That's why it's not been, so they're quite glad that it's not been notified. But what has happened, you must understand, to answer your question, is many of the provisions relating to whistleblowers have now been incorporated as regulations into the Companies Act. For instance, this case that you are mentioning, if you have a complaint and you think the company has not taken action, it is essential that the person would write to the audit committee. And the audit committee today has a whole lot of rules and regulations, and the director knows that if he is not going to address this and find a solution to the problem, he could be criminally prosecuted. We talked about limitations of director's liability, but all this does not help a director if he is going to be sued in a criminal court. So that is the answer. There is answer in the provisions of the Companies Act which will ensure that there is a solution.
Thank you. Any more questions? We can probably take one more question. Yes, please.
Good evening, I'm Tarun. I'm a fourth year pursuing my BA LLB. So I think the panel has addressed a broad range of issues relating to corporate governance and also relating to the recent privacy laws. So I just want to discuss something relating to competition law, if I can. So I think a lot of regulatory regimes have brought in new competition laws to regulate digital markets. I think the main concern there is platform markets. I think platform markets avoid liability in the sense that they call themselves intermediaries and they take a safe harbor provision which is available under many laws, like Section 79 of the IT Act as well. Now, while India wants to focus on ease of doing business, wants FDIs and all of that, how do you ensure that these platforms are also held liable for their actions?
Have you gone through the provisions of the Consumer Protection Act 2019? Do you know what are dark patterns?
Yes, sir.
So there are 13 different types of dark patterns which have been identified, which many of them would answer your question with regard to regulating competitions. This is still, once again, for all of you who think you must make a mark in the profession, under the Consumer Protection Act, this is again going to become a major area. 13 identified dark patterns. Please read that. And the CCPA, the Central Consumer Protection Authority, is emerging as a powerhouse of regulating competition, and it is duplicating, it is not duplicating, it is mimicking the functions of the Federal Trade Commission in America. But the Federal Trade Commission in America is far more effective than the CCPA. The CCPA, please track what they have been doing recently, very good work. And this is only the last 2 years, even though the act was passed in 2019, after 4 years, it's only the last 2 years that CCPA has picked up energy. There's lots more that they have to do, but it's a good direction in which they are traveling. That would be an answer to the question. Please read about the 13 dark patterns and the trade in platforms and how they are regulated now.
Our time's up. Thank you so much, dear panelists. This has been such an insightful session, and I'm sure all the law students in the audience feels the same way. Thank you so much.